Hi, this is Rahul Reddy. We are live from Houston, Texas. I'm the business partner in REDDY NEUMANN PC. We are here to answer your questions with regards to the immigration. As usually, we come every day, every Tuesday live at 5 Central Time. Along with me is my business partner, Emily Neumann. Emily?
Thanks for joining us today. My name is Emily Neumann. I am the writer behind the blog immigrationgirl.com. So if you want the latest updates on immigration in between our weekly Facebook Lives, you can always go there to get the latest news. And, we've been practicing immigration law. The firm has been around for 21 years now. So we are here to help you answer your questions. If for some reason we're not able to get to your question today or you need a more detailed response, you can always set up a consultation with us or any of our attorneys by going to rnlawgroup.com. So some of the topics we're going to be covering today include the H4 EAD, the latest regulatory agenda and all of the different regulations. The Department of Homeland Security is wanting to change H-1B lottery is included in that, as well as the public charge regulation that came out recently, a proposal. So we're going to talk about all those latest news in immigration and what to expect in the pipeline going forward.
I mean, what do you think so with all these regulations, the proposals that you're speaking about? Is it going to make easy for the immigrants or is it going to make harder for the immigrants?
Yeah, it's definitely not going to make things any easier. The idea is clearly to restrict legal immigration as much as possible. Trump's goal is to move towards a merit-based immigration, which we really kind of have for employment-based immigrants, but he wants it even more so. So those are the kinds of changes to expect. How are they going to be running the lottery, making specialty occupation likely more restrictive, more restrictions on employer-employee relationship. So that's what we can expect in the coming months, I would say.
We're going to take the live questions as usual on both the channels that we have. Emily, on this issue of the CPT, day one CPTs, have been advocating a lot of times that things were not doing good with regards to the people who are in day one CPT. That might not be legal, but now all of a sudden, unlike previous years, now we are seeing unprecedented denials of the H-1B for those people who are in CPT. What are the options for them when the change of status from the CPT to H-1B is being denied and the H-1B is approved? Can they appeal? Can they file to motion reconsider? Or can they just ignore the H-1B, continue working on the CPT?
Yeah, so I'll start with your last question. Once the change of status from F1 to H-1B has been denied due to a status violation, that means you're no longer in F1 status either. So remaining and continuing your CPT is definitely not an option. Your first option is to depart the United States and apply for the H-1B visa stamp at the consulate in your home country. As far as options for fighting the decision, you have to understand that there is no appeal of a change of status denial. You can appeal the H-1B petition itself being denied, but just the change of status portion cannot be appealed. You do have the option of filing a motion to reopen or a motion to reconsider. A motion to reopen requires new evidence to be submitted that wasn't asked for earlier or wasn't available earlier that would have changed the outcome of the case. So most likely a motion to reopen is not going to be applicable, but a motion to reconsider is where you do not provide new evidence. You basically are arguing that the decision was wrong based on all of the documentation and information previously provided. Maybe there was an error in how the decision was made. Now, as of right now, based on how USCIS is interpreting the plain language of the regulation, I'm not sure how likely a motion to reconsider is going to be successful. And you have to realize that filing the motion to reconsider does not put you back in any status. It does not stop unlawful presence from accruing. unless the case is actually reopened and reconsidered and approved. Then it's as if the denial never happened. But here it's a pretty big risk to take, because remember, when we have that CPT denial, the change of status denial due to a status violation, it counts from August 9th or the day you started CPT, whichever is later. So you have to be careful of that 180 days.
Yeah, and then so the motion to reconsider is it's going to be dangerous because they're going to cross 180 days. Then they will have a 3-year bar coming back into the United States. It might be very advisable for these people to leave the country when the change of status has been denied, because unlike previous to August 9th of 2018, where your unlawful status started counting since the day of denial, since the August 9th memo went into effect, the unlawful stays counting from the day you violated the status or August 9th of 2018, whichever is the latest. So from August 9th, you're accumulating. On February 6th, you're going to hit the, February 4th, you're going to hit the 180 days. You're going to have a 3-year bar. I would advise you to leave. I would advise you to contact a lawyer, sit down with a lawyer to make any options that you have. Emily, in the daily conference calls that we do conduct every day for all the people to ask questions, we do conduct every day half an hour for all the people to come in. In the past 1 week, and in today and yesterday, I have noticed an unprecedented number of people indicating that their change of status was being denied from the STEM extension to the H-1B. Now, as we know that in January of 2018, the USCIS updated the website saying that they cannot work at a third party site. Then they changed it saying that they could work at third party site. But the change of status was not denied because they were working at third party site. The change of status was denied because the employer did not comply with the 983 form and the regulations that are required for the STEM extension. That's the reason why their change of status was denied. Is there a different story for these people as compared to the CPT, or do you advise the same thing what you told about the CPT people?
Yeah, I think that, depending on the evidence submitted, perhaps a motion to reopen might be possible in that case, but it really depends on the specifics of the situation. If the employer truly did not comply with what they said they were going to do in the training plan, then I don't think a motion is going to be helpful, and you've got to make sure that you exit the country to apply for the visa stamp before you cross that 180 days. So that the STEM OPT regulations have a lot of requirements for employers in order to comply with, and so employers have to fill out the 983 form, provide that training plan, specify how they're going to be doing the training, how they're supervising, answer all of the questions on that form. But just filling out the form isn't enough. You actually have to follow through with everything you said you were going to do, and that's the situation where people are seeing a denial of the change of status because the employer did not follow through with the training plan.
Emily, you have published an article with regards to the public charge that the Department of Homeland Security is. Do you think so that the employment-based immigration people should be concerned about this proposed regulation, or you think so they might not have to be that much concerned?
I think that the typical high-skilled immigrant is going to be usually paid a higher salary and will be able to meet whatever public charge requirements they provide in most situations. As of right now, what it looks like they're proposing to do for employment-based immigration is at the time you're filing your extension or a change of status, you'll have to somehow attest that you've not been a public charge, that you've not used public benefits, and then USCIS has the option to go beyond that and ask you to fill out a much more detailed form. So I think that the majority of high-skilled immigrants probably are not using public benefits, and so it's not going to come up as much. We might see it in situations of maybe a change of status from F1 to H1. If students, you have your broke college students that might be scraping by in order to go to school, they may have difficulty showing that they have not or will not become a public charge.
Emily, as usual, you're the first one to publish any of the business immigration articles on your blog, which is immigrationgirl.com. Now, you did publish this DHS regulations that's going to affect the H-1B quota, H4 EAD, the adjustment of status, the F1 non-immigrants, B1 visas and B2 visas. Now, I'm going to ask you specific questions. First is, a lot of audiences are asking the question on live. What about the H4 EAD in this DHS regulatory agenda? When do you think so it's going to pass? And when do you think so, it's almost certain that they're definitely going to restrict the H4 EAD. They're not going to expand the H4 EAD. When do you think so the regulations are going to be passed? Does it mean those people who are in H4 EAD will not be able to work even if they have the validity period?
So as of right now, it looks like we should expect a proposed regulation by the end of the year. Now, as far as, I didn't check it today, but yesterday there was nothing submitted to OMB yet, and that is a required first step before they can publish it. So sometime in the next few months here, we should see an actual proposal to change the H4 EAD regulation that exists right now. Now, once they propose it, the existing regulation continues. So you can still file the H4 EAD, you can still get the renewals. Nothing changes until a final regulation is actually published and takes effect. Now, how long will it take for that to happen? Typically, once they publish the rule, you're looking at 60-day comment period, followed by several months of the Department of Homeland Security having to actually review those comments and then coming up with their final rule, submitting the final rule to OMB, and then finally publishing it with usually some kind of advance warning so that the rule doesn't take effect until maybe 45 or 60 days after it's published. So nothing's going to happen overnight. Probably at least 8 months, maybe 12 months, maybe 18 months. These things do not happen quickly. As you can see, we've already had so many delays. This proposal was supposed to come out in June, if I remember correctly, according to last year's regulatory agenda. Now we're looking at maybe December. So it's not going to be a fast process. Now, what's going to happen to existing EADs? We have no way of knowing until they actually propose a regulation and let us know what they're thinking. But based on prior experience with how they've handled this situation for TPS, for DACA, when they were removing those work authorizations, they allowed people to continue until they expired, and then they did not allow people to renew after a certain date. So I would expect they would give the same courtesy. I would expect there's probably going to be some litigation. Perhaps, maybe we can see some immigration legislation that would provide this benefit. And the whole idea, what I expect Homeland Security to be as their reasoning why they want to get rid of the H4 EAD is that they think only Congress can do that, that they weren't authorized to give these EADs, and therefore they were in violation and shouldn't have been doing it in the first place. So Congress is the one that could fix that problem by passing a bill that creates the H4 EAD by statute, or passing a bill that solves some of this immigration backlog. So those are things that we'll need to be fighting for as this H4 EAD regulation continues to go through the process.
I'm going to go live to some of the questions. One of the compliment Cookie has said in the YouTube is that they missed us live last week. We did publish it, but we were unable to keep live last week on YouTube, but we were live on the Facebook. But I'm going to go to questions from YouTube. You're going to go questions with the Facebook, so we're going to answer each of them. Can a H-1B renewal on premium processing include a little bit change for the same employer and file it in Nebraska Service Center? This question is coming from Majumdar.
Yeah, we've so far been able to file some extensions with Nebraska where there are some minor changes involved, where the major terms and conditions of employment are the same job, same employer, same work location, same job duties, maybe we chose a different SOC code, maybe the wage level increased this time around since we're filing this 3 years later. So far, those types of changes have not been an issue for getting the case in premium processing in Nebraska. As more and more people figure that out and try to route their extensions to Nebraska so that they can get the premium processing, they may change their mind on that. But as of right now, minor changes seem to be okay.
Cookie has this question. He's on H-1B and he's an L-1B and he has received the second RFV on the extension of the L-1 visa. Can he go to his home country and work there, or what will happen to this L-1 extension?
Well, the L-1 extension, the petition itself can still be approved even after you exit the country, but in order to come back, you'll need the approval at some point and you'll have to apply for the new visa stamp at your home country. So yes, that may be possible to exit while it's pending, wait outside for the approval, and then get the new visa stamp to come back.
Sidhu has this question from YouTube. He has a mechanical engineering degree. Is it the right time for him to move? Is it okay for him to move to a different company because he's working for the IT field, or what do you expect?
That's getting more and more difficult right now, even with an education plus experience evaluation. So it really depends on how much experience you have, how strong the evaluation is. They are really second-guessing evaluations done by professors that some of these services provide when before they were never questioning those. So yeah, it's not easy right now. If you have a somewhat unrelated degree and you're trying to file, you may get a request for evidence on beneficiary qualifications, and be prepared to really get a strong evaluation to respond to that. On Facebook here, we have a situation that we've actually come across before. When it comes to a U.S. master's program that actually is a for-profit. So
university.
So the problem with that comes in the cap. A lot of people back in the day didn't realize that for-profit universities couldn't be filed in the master's cap, and they filed them in the master's cap, and USCIS was approving them. Now, 3, 6, 9 years later, when you're
3, 4, 5 extensions, 3 transfers.
Yeah, they're actually still looking at that issue and coming back and issuing notice of intent to revoke or a notice of intent to deny on the grounds that the very first H-1B was improperly approved. And we've seen that in our office as well. One of the solutions that we've worked on is to plan to file in the cap in April, so that you can be counted in the cap if ultimately your current petition ends up being revoked. And then you basically start over in the lottery, hope you get selected, and assuming all of that works out, that's really the only way to correct a problem like that, is to now file in the cap.
Can I travel to India while the H-1B transfer in process? The easy answer is no, because once you travel outside the country while the transfer is in progress, it is considered that you have abandoned the transfer application though. You have not abandoned the H-1B, but you have abandoned the transfer application. So you have to wait until the H-1B approval, and then you have to go to the stamping. Maybe you can avoid the stamping depending on when your stamping is available. But you have to wait until the H-1B transfer is approved before you come back into this country. Especially now the premium processing is not there, and if there is going to be an RFE on it, who knows, it might take an year for you. And I do suspect that in that period of time you may lose the job, so I would not advise at this point of time for him to, this question comes from Kishore from YouTube.
All right, Sachin has a question about the H-1B grace period in the event that you're terminated from employment or laid off. The January 17th, 2017 regulation provided for up to a 60-day grace period to allow you to find a new employer and file a transfer, or potentially file a change of status, or to prepare to depart the country. So the question is, if assuming the I-94 is valid, which that's a requirement to get that 60-day grace period, what happens if the old employer withdraws the approved petition during the 60 days before the new employer is able to file the transfer? And in my opinion, that shouldn't have any bearing at all.
Yeah, just because the previous employer has withdrawn the petition will not have any effect whatsoever at all on your 60-day grace period. The 60-day grace period has been granted in the regulations to you. It doesn't depend if your employer has withdrawn or not withdrawn. In fact, actually, it practically is mandatory for the previous employer, if he is not employing you, to withdraw your application. So I don't see any reason why the withdrawal will have any effect on your H-1B transfer if you're transferring within 60 days. This question live from YouTube, Emily. This is from Kishan. His H-1B is still pending into the new quota. His term extension is still pending. What are your thoughts?
Well, the STEM extension pending allows you to continue to work for up to 180 days after your current OPT expires, and the H-1B has no bearing on that. If you're getting close to that 180-day mark, hopefully you're not. We don't see that many that go that long, but definitely be following up, submit service requests well before that. I think you normally can submit a service request around the 90-day mark, 100-day mark. So as long as it's pending and you're under 180 days, you can continue working. And same thing with the H-1B. If it is beyond normal processing time, maybe there was a request for evidence that was responded to more than 60 days ago, the employer or their attorney can submit a service request for that as well. Other than that, there's not a whole lot of ways to expedite. I've received quite a number of messages over the last day or two from people who tried to expedite their pending H-1Bs under USCIS's expedite scenarios, making the argument that they're going to undergo severe financial loss if they have to stop working due to the cap gap ending, and I have not seen USCIS approve any one of those.
I don't think so. The USCS has the heart there. I think so. They're doing purposefully to delay this, not taking the premium processing off. Mm-hmm. Anything from you, Emily?
Let's see here.
How safe it is, this is from Munna, how safe it is to travel when the H-1B amendment is in process? No, don't travel, because you cannot come back if you travel, because unless your amendment is approved. The problem with that is right now there is no premium processing for it. So if you go outside the country, when you're coming back, your previous H-1B was approved for a different end client. Now you are not working with that end client. And with this second end client, the petition, underlying petition, is not approved. So I'll be very surprised if the Customs and Border Protection people will allow you back into this country. So I do not recommend that you travel.
All right, Pula has a question. He's got a valid H-1B through August 2019, filed a transfer to a new employer, did not join the new employer, was waiting for the approval, and it got denied. So he's stayed with the current employer, and he wants to know what kind of impact that denial of the transfer will have on him, at the time he's filing an extension with his current employer, or if he transfers to another employer.
Absolutely, it will have no effect, none whatsoever at all. Since you're still working for the company that has the H-1B validity until August 19th, it will not have any effect whatsoever at all, because the company B's transfer has been denied.
All right, Maheshwar asks how things are at the Nebraska Service Center compared to California or Vermont. Right now, I'm a big fan of Nebraska. They are, they're looking at petitions that have been previously approved under the same terms and conditions. So as long as those same terms and conditions of employment continue, they generally will be able to approve those. And they're more looking at, did you maintain your status during your prior period, or was there some kind of violation? They're not so much looking into, is it a specialty occupation? Is the beneficiary qualified for the position? Now, of course, if the prior approval was completely gross error, in that the person really wasn't qualified at all, but the officer approved it anyways, they could still question qualifications. They could still question specialty occupation. So it doesn't mean you're completely out of the woods, but we do tend to see a slightly fewer RFEs from Nebraska and higher approval rates from Nebraska right now.
Sony has this question from YouTube, Emily. RFE did not question about the status or the education qualification. Is there a chance that the USCIS might come back and issue a second RFE on either of these two topics? Most probably seems to that he got an RFE on the specialty occupation.
Yes, we started seeing that much more often last year than ever before as those second RFEs. Knock on wood, so far this year we've not had a second RFE on those that we've responded to, but they absolutely can come back and ask more questions if they find other issues, unfortunately.
Question, Desai has a question from YouTube, Emily, is that they responded to the RFE 2 months ago, and how long is it taking for them to act on it?
Yeah, most of them are being adjudicated within about 60 days. We've had some that were approved in 2 to 3 weeks after an RFE, which is kind of unusual, but yeah, about 60 days. If it goes beyond that, the employer or attorney should be able to put in a service request for outside normal processing time. Verinder has a question about what options there are in the event that the H-1B petition gets denied during the cap gap. Now, of course, at this point, we've already finished the cap gap, so this, may be a discussion about a previously denied petition. Generally, if the H-1B is denied during the cap gap, you should have the 60-day grace period at the end of your F1 and OPT in order to decide to depart, in order to file a change of status to something else, or in order to enroll in a new program. That being said, we have seen some weird glitches in the system, in the SEVIS system, where the SEVIS record gets terminated due to the H-1B denial. The DSO then has to request a data fix. That takes time to process in order to get the person back into F1 status so that they can transfer schools or move into a new program. SKS has a good question in the YouTube. He's saying that he is nearing the 240 days of the extension. As we already know that if the extension is pending, the I-94 has ended, you can only work up to 240 days. What are his options if the 240 days are nearing and his extension is not approved, and you know that premium processing is not there in some cases? Mm-hmm. I am hoping that this guy falls into a category where he doesn't fall into premium processing, because I don't see a reason why he should not do premium processing. So in the case where he's not eligible for premium processing in extension plus amendment, what are the options? So the pending extension puts the person in a period of authorized stay that allows them to remain in the country as long as it's pending. What ends at the 240-day mark is your employment authorization. So option one is you stop working at day 240 and you just remain in the country waiting for the decision. That can be a bit risky, because if the petition is ultimately denied, your I-94 is long since expired, you're immediately out of status, immediately start accruing unlawful presence. Option two, to be able to continue working, you could file an extension of the 240-day pending petition specifically to get that work authorization. So it's just like filing another extension based on the first pending extension, but allows you to get that another round of 240 days. Now, as far as I'm aware, there's no specific USCIS guidance on that, but this is a method that seems to be working based on our own cases and those of other attorneys to allow the continued employment authorization beyond the 240 days.
Ramya has this question. While the decision of reinstatement for F1 status, and this is coming up very often in the conference calls that we do conduct every day, Emily, is that this change of status has been denied because of the violation of the CPT, or the employer violated the STEM extension part of it. They're asking the question that the employers are now wanting to go and wanting to get their student visa reinstated. Can they work while the reinstatement is going on?
I don't think so.
I don't think so.
The purpose of reinstatement is to study.
No, you cannot work while the reinstatement. I'm pretty sure you cannot work on reinstatement. Not only that, you need to be fearful for those people who are advising this, because if you're applying for reinstatement, you already got the denial, you may be accruing the unlawful status, most probably from August 9th of 2018. The reinstatement will take its own sweet time. You cross a February 6th, you will be in great trouble if your unlawful presence will be crossing 180 days. I would recommend that you go to RN Law Group website, read the articles that we published on this 180-day rule that we have done. And also you can go to immigrationgirl.com in the blog and study what this August 9th memo is, how it's going to affect. So in your case, I will be troublesome to go for the reinstatement. If the reinstatement gets negative, you probably will not be able to come back into this country, ever, most probably.
Venkata has a question from Facebook. His wife has filed her H4 and H4 EAD renewals, and they're still pending. Is it possible for the EAD to be approved while the H4 is still pending?
Is it possible? No. Legally, it's not allowed for the officer to approve the EAD without the H4, because if the H4 validity is not there, the officer cannot approve the EAD. So I don't see any possibility. Now there are some mistakes I've seen, very rarely, 1 in 1,000 that they have done, but I have to see that and evaluate it. But either way, it's not legally allowed for the officer to approve the EAD without the H4 extension.
All right, Stravia has a question from Facebook. Ending OPT time is coming soon and looking for the next options. Which is better, H4 EAD or PhD with day one CPT?
Hands down, it's H4 EAD. No questions asked about it. Now, right now, the H4 EAD is there. As Emily has pointed out, that from June of 2018, we're expecting the H4 EAD regulations to be issued. They have not been issued. We don't know how long it's going to take for them to issue. And even if when they're issued, when you see the executive order issued for the undocumented aliens, where 900,000 people were given the employment authorization, they said that the people that have the extension, the EADs can keep it. They still will be allowed to file up to a period of 3 months for those, once the executive order has been issued, to file for the extension, so they are allowed to work. I'm hoping that the administration will give you the same courtesy what they have done for the undocumented aliens in this country. So H4 EAD, hands down, is a better option. Second option, day one CPT, absolutely not a good option. You are actually entering into a what do you call, the hole with and the lion is there. What do you call it? Den of a lion, and not sorry, I couldn't get the word immediately. You're entering in a den with a lion, and you're not going to score that. Absolutely not a good option to go for CPT at all.
All right, Pankaj has a question. And this is coming up a lot since the matter of Simeo guidance that requires an H-1B amendment to be filed when there's a work location change that moves you outside the MSA or the normal area where your current petition is valid for. So we're seeing a lot of times people that have a 3-year approval, and then when they file their amendment, they get only a 1-year approval. How does that impact accompanying H-4s? And how does that impact the H-1B holder once they get to that 1 year. As far as the H-1B holder, that 1 year approval, that's your new I-94 stay.
Validity.
And so if you're going to continue working at that location, an extension has to be filed by the time you get to that date, not the 3-year date. Now it's a little bit different for dependents because their H4 is tied to your status. So as long as you're in status, in H-1B status, then the dependents who have valid I-94s can continue in their status. So as long as you file your extension on time, their H4s should remain valid because you're staying in status and they already have the approvals. But there's not any guidance on this, and it is very problematic because we have everyone's got a different end date, it seems like these days, and you've got to figure out when is the time that you have to file the extensions for the H1, for the H4, for the EAD. It really does need to be cleared up, and unfortunately I wouldn't expect to have any guidance on that anytime soon.
Pawat already has the question that what are the chances for the RFE for the specialty occupation to be approved if you are being issued an RFE on a specialty occupation?
Really depends on the job and what the education requirements are, what documents were already provided, and what's being provided now. So just because you have that specialty occupation doesn't mean the petition is doomed. That being said, if the petition was filed in an occupation category that's not very strong, that doesn't have good documentation in the Occupational Outlook Handbook that says that a degree in a specific field is required, then you've got an uphill battle. So it depends on a lot of factors. There's just no way to say percentage of approval or versus denial is X or Y, because it is completely dependent on what was filed and what's being submitted.
Also, when you are applying for the H-1B, before you apply for the H-1B, then the new quota, extension, amendment, and transfer, it's better that you sit down with the employer, you consult with the lawyer to make sure that what are the probabilities to approval for each of the position, for the salaries that you're speaking, for the job description you're speaking, what are the probabilities for approval. An experienced lawyer can guide you properly to tell you how this is going to work. Based on that, your HR and then your HR and you can make a decision if you want to take that position or you don't want to take that position, you want to take that job or you don't want to take that job. So it might be better for you to evaluate it. Now, I have to tell that in my 21 years of experience, or 23 years of experience, or 21 with the REDDY NEUMANN PC, but before 2 years, 23 of experience, it's quite different in the past 2 years doing an H-1B as compared to what it was in my previous 21 years of H-1B practice. It's quite different. Everything has changed right now. The lawyers have to update everything. It changes every 3 months, every 4 months. The system analyst was a holy cow for a long time. All of a sudden it has become a Satan right now. And a lot of the positions, level 1 was never questioned before. All of a sudden they started questioning level 1. Specialty occupation was an issue. For rarely we used to get those things before. But that has become very common, the specialty occupation. The degrees, if they were in engineering, even if they were not in a computer science, used to get passed through the H-1B previously at a very good rate. Now they are becoming a problem. So all these things are getting questioned. Level 1, system analyst, the title, the job description, the end client letter has to be perfectly matching. The end client letter should be issued properly. All those things used to be quite different previously. So when you sit down with an experienced lawyer who is currently updated in all the H-1B issues, he would be able to guide the HR, what are the probabilities for your position. A generic answer, well, an H-1B, a specialty occupation can be approved, it's very hard to answer. It has to be more specific to your job description, to your employer, to your HR, and the end client. Is the end client willing to issue a letter? If the end client is not issuing a letter in the format in which your lawyer wants to, that might affect your H-1B too. Even though you might have a good position, you might have a good level, but the end client is not willing to issue a proper letter in the format in which your lawyer wants, that might affect your H-1B too. So you need to consider all these factors when you are applying for an H-1B. Especially under the circumstances where we are right now, the denials have gone up more than 25% right now. That is humongous. 25% plus H-1Bs are getting denied. You better be very careful before you take a job, before you apply for H-1B.
All right. Neha has a question on H4. So she's in the U.S. on H4, does not have the EAD. If she's in the U.S., can she work for an employer in her home country remotely? Would that be a problem?
Well, it's very sad, Neha, that you are on H4 and you don't have an EAD. I understand the pain what you're going through. I was on H4 before, and I actually had a license to practice as a lawyer, and I was on H4, and I couldn't work. I did volunteer in some legal aid society, but I couldn't work in any paying positions. In the question, what you're asking about is that can you work logging in India or any other country? The answer is clearly no. The government at this point of time does not recognize the cyberspace. They only recognize the chair where you're sitting, the chair where you're sitting. The cyberspace where you are at, where you're roaming at, does not count at this point of time, particularly to the United States and maybe most of the other countries too. So if you are sitting here in United States, you're working in outside the country, it is considered that you are working in United States. You do not have the work authorization, so you cannot work. You can volunteer for some Red Cross or something like that, but other than that, you practically cannot work anywhere.
Ooh, we got a lot of questions on Facebook. I'm falling way behind. I don't know if
340.
we're gonna get to them all.
A lot of questions on YouTube too, Emily.
Let's see here.
Can I amend the H4 EAD to submit a new I-94 which has a longer validity? Now, you cannot amend a H4 EAD, but you can file an extension of the H4 EAD. You just file an extension. If you have now a longer validity period, I would file an extension though. Now, though there is a limit of 120 days before that you cannot file for the H4 EAD extension, I have seen though that USCIS routinely extends it even when people have filed before 120 days. Now, I do caution you that they may deny it, but it's not going to have a negative effect if by any chance the extension is denied. So instead of amending it, I would file an extension of the H4 EAD.
All right, I have a question on H-1B transfer denial. Can I work for that company once an appeal is filed? The answer is no. The denial of the transfer puts you out of status. You're not unlawfully present if your I-94 is not expired yet, but you are out of status, and just filing the appeal does not put you back in status. So you cannot work until your appeal is actually successful and the case is reopened. Once it's reopened, then you should be able to go back to work. They treat it as if the denial never happened, but just filing an appeal does not give you work authorization or status.
Jairaj from YouTube has this question, Emily. Guard unlawful presence H-1B denial while doing an CPT. What are the impacts of him? What does he need to do?
Well, number one, you have to look at when did the unlawful presence begin to accrue and make sure that you take action before it crosses 180 days. Now, without knowing the specifics of the situation, we can't say, you need to leave or you need to file a motion to reopen or what your options are. But if leaving is the best strategy, then you need to do that before 180 days. Then, assuming your H-1B petition itself was approved, you can apply for the H-1B visa stamp at your home country consulate. You have to make sure that you answer the questions properly, that ask, have you ever violated your status? Have you ever been denied a visa? Those sorts of things. You need to answer those properly and provide the information and be prepared to explain it in the consular interview. But as long as you've not crossed the 180 days, the denial of the change of status by itself shouldn't be a reason to deny your visa to come back. But you do have to make sure that you don't misrepresent anything during your visa interview.
Vikram has this question. If you downgrade from EB2 to EB3 and file the adjustment of status, what will happen to the EB2 approval? Vikram, nothing is going to happen. It's going to still be there. I mean, you can always reuse it if you want to, but there are certain conditions that will be attached to it. But just because you're filing an EB3 doesn't mean that your EB2 is going to be void. It still is there, but there are limitations how you can use that EB2 though.
Ankit has a question about working for a startup company on OPT, which is absolutely fine, no issues there, but what about when it's time to file the STEM extension? As you know, to be eligible for the STEM extension, the employer has to be in E-Verify using that system. Can a startup enroll in E-Verify? Yes, absolutely, no issues there. There's no requirement for you to be in business for a certain length of time or have a certain number of employees before you're eligible. As long as you have an employer tax ID number, the FEIN number, and you're an employer, you can register for E-Verify. Just be aware that the STEM OPT time must be paid. So if it's a startup, they need to have sufficient funds to be able to pay you for your work once you start the STEM extension.
It's time right now.
I think so. So we had lots of questions today. Sorry we couldn't get to them all. Feel free to join any of our daily conference calls where you can. It's very similar to this, except for you'll speak live with an attorney and ask your questions there. The schedule for that is on our website at rnlawgroup.com. So check that out. You can always set up a consultation with us or any of our attorneys at rnlawgroup.com as well. And feel free to follow us on Twitter at rnlawgroup or follow me at Immigration Girl on Twitter. And subscribe to immigrationgirl.com. That way you'll get an email whenever I post a new article. And I promise I don't spam your email. It's only when I post something new you'll get an email.
And then when you try to make an appointment with RN Law Group, try to make an appointment with the lawyers that are, all of our lawyers are well versed. You don't have to just make an appointment with Emily or me. There are other lawyers in our office that are equally or if not better competent than we are. So please don't hesitate to make an appointment with any of them to speak with them anytime for any questions that you have. When you do make an appointment, we request that you provide all the documents before the appointment time so that we can speak with you based on the documents.
All right, thanks for joining us, and we'll be back next Tuesday.
Thank you.